In this lecture, we'll make a critical review on the NDPS Act of 1985, which exactly called as the Narcotic Drugs and Psychotropic Substances Act 1985, and which was enacted by the Parliament of India, which prohibits the very production, manufacturing, cultivation, possession, sale, purchase, transfer, storage, and or consumption of any narcotic drug or psychotropic substance. So, the NDPS Act has, since its inception in 1985, has been amended 5 times, in particularly in the year 1988, then again in 2001, then in 2004, and 2021, and finally recently in the year 2025. The Act extends to the whole of India and applies also to all Indian citizens, even outside India, and to all persons on ships and aircraft registered in India. So, the very act and the law relates to narcotic drugs to make stringent provisions for the control and regulation of operations relating to narcotic drugs and psychotropic substances, to provide for the forfeiture of property derived from or used in such illicit traffic in narcotic drugs and psychotropic substances. The very purpose of its enactment was to implement the provisions of the International Conventions on Narcotic Drugs and Psychotropic Substances, which were enacted first as the Single Convention on Narcotic Drugs in 1961, then on the Protocol on Narcotic Drugs and Psychotropic Substances Act at Geneva in 1972, then the Convention on Psychotropic Substances in 1971 at Vienna. So, now exactly we would like to discuss the very historical background for which this very act was enacted in the year 1981. So we will go to the prehistory civilization of India, then the very development during the British period, and finally the American pressure on Indian government and the parliament to enact the Narcotic Drugs Psychotropic Substances Act 1985. India had no legislation regarding narcotic drugs until 1985, and cannabis smoking in India has been known since at least 2500 before Christ, and its first mention we found in the Vedic Shastras, in particularly in the Atharva Veda, which dates back few thousand years before Christ. The Indian Drugs Commission An Indo-British study of cannabis usages in India was appointed during the British imperialism on India in 1893, and it found that the moderate use of hemp drugs was practically attended by no evil results at all, produces no injurious effects on the mind and no moral injury whatever. Regarding excessive use of the drug, the Indian Hand Drugs Commission concluded that it may certainly be accepted as very injurious, though it must be admitted that in many excessive consumers, the injury is not clearly marked. The report of the commission produced was at least containing 3,281 pages long with testimony from almost 1,200 doctors, coolies, yogis, fakirs, heads of lunatic asylums, bhanga, peasants, tax gatherers, smugglers, army officers, hemp dealers, ganja palace operators, and the clergy. Cannabis and its derivatives such as marijuana, hashish, or charas, and bhanga were legally sold in India until 1985, and their recreational use was commonplace. Consumption of cannabis was not seen as socially deviant behavior and was viewed as being similar to the consumption of alcohol. Ganja and charas were considered by upper class Indians as the poor man's intoxicant, although the rich consumed vangas during festivals, in particularly during the festival of color, which is otherwise called Holi. The United States began to campaign for a worldwide law against all drugs following the adoption of the Single Convention on Narcotic Drugs in 1961 at New York. However, India opposed the move and withstood American pressure to make cannabis illegal for nearly almost 24 years. American pressure increased in the 1980s, and in 1985 the then government led by the late Rajiv Gandhi, the Prime Minister of India, finally enacted the NDPS ACT, banning all narcotic drugs in India. So now we will go to the very definition as given under the Act, in particularly under Section 2 of the Act, and those definitions that we found under Section 2, in particularly subsection 3, subsection 4, subsection 5, subsection 6, and also under section 2, subsection 15, 16, 17, and 18. So, while defining exactly under section 2, subsection 3, cannabis and its derivatives such as marijuana, hashish, or charas, and bhanga, as it defines cannabis as hemp and which particularly means charas, that is the separated resin in whatever form, whether crude or purified from the cannabis plant, and so also include concentrated preparation and resin known as hashish or liquid hashish. Ganja, that is the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves when not accompanied by the tops, by whatever name they may be known or designation. So any mixture, with or without any natural material of any of the above forms of cannabis or any drink prepared therefrom. So the very cannabis plants as defined means any plant of the genus cannabis, and in particularly while defining coca derivative as under section 2 and in particularly subsection 5, crude cocaine, that is any extract of coca leaf which can be used directly or indirectly for the manufacture of cocaine. So also cocaine, that is methyl ester, and its salts and all preparations containing more than 0.1% of cocaine, and while coca leaf as defined under section 2 subsection 6 means the list of the coca leaf of the coca plant, except a leaf from which all cocaine and any other alkaloids have been removed, any mixture thereof with or without any natural material, but does not include any preparation containing not more than 0.1% of cocaine. And while exactly defining coca plant as under section 2, subsection 7, coca plant means the plant of any species of the genus. So also the act defined exactly as under section 2 regarding what is opium. So as it is being defined under section 2 subsection 15. So in particularly it means the coagulate juice of the opium poppy and any mixture with or without any natural material of the coagulate juice of the opium poppy, but does not include any preparation containing not more than 0.2% of morphine. So now we'll discuss about the very definition of opium derivatives as it is defined under section 2 subsection 16. Opium derivative means those prepared opium, that is any product of opium obtained by any series of operations designed to transform opium into an extract suitable for smoking and the dross of other residue remaining after opium is smoked. And now we'll go to the next definition, that is relating to subsection 17. So, as it is provided regarding the definition of opium poppy, so the very plant of the species of any other species of papaver from which opium or any alkaloid extracted and which the central government may by notification in the official gazette declare to be opium poppy for the purposes of this act. And also we found the very definition of poppy straw. So as it is defined under section 2 subsection 18, poppy straw means all parts except the seeds of the opium poppy after harvesting, whether in their original form or cut, roast, or powdered, and whether or not juice has been extracted therefrom. So, these are the very definition of cannabis, its derivatives also opium, opium derivatives as it is being defined under section 2 of the act, and that is NDPS Act of 1985. So now we'll go to our third part, that is regarding the very procedure provided under the Act under section 41 to 45 relating to warrant, issue of warrant, entry, search, seizure, and arrest as it is provided from section 41 to section 45 of the Act of. So, in particularly, as it is provided that the very procedure under section 41 of the NDPS Act is the power to issue warrant and authorization of issuing warrant. Then section 42 provides the power of entry, search, seizure, and arrest without warrant or even without authorization. And section 43 provides power of seizure and arrest in public places. Then section 44 provides power of entry, search, seizure, and arrest in offences relating to hookah plant, opium poppy, and cannabis. And finally, section 45 provides the very procedure where seizure of goods liable to confiscation, not practicable for storage. And now we'll discuss about the power of attachment and source of convenience as provided under section 48, 49, and 50 of the Narcotic Drugs and Psychotropic Substances Act 1985. So, in particularly relating to the power of attachment as per section 48 of the Act, the power of attachment of those crops illegally cultivated relating to narcotic drugs and psychotropic substances. And as per section 49, it provides power to stop and search such conveniences which are relating to transporting of such products relating to cannabis and its derivatives or opium or coca derivatives. And finally, Section 50 of the Act provides those conditions under which such of persons shall be conducted. So it provides those conditions. And now we'll go to our fourth most important part, which relates to offences and penalties, and in particularly provided under section 15 to section 32, which now we will discuss in a brief way, and it particularly relates to, as per the provisions of section 15, punishment for contravention in relation to poppy straw, and section 16 provides punishment for contravention in relation to coca plant and coca leaves, while section 17 of the Act provides punishment for contravention in relation to prepared opium, while section 18 provides punishment for contravention in relation to opium, poppy and opium, while section 19 provides punishment for embezzlement of opium by cultivators, and section 20 provides punishment for contravention in relation to cannabis plant and cannabis, while section 21 provides punishment for contravention in relation to manufactured drugs and preparations, while section 22 of the Act provides punishment for contravention in relation to psychotropic substances, while section 23 provides punishment for illegal import into India or export from India or transshipment of narcotic drugs and psychotropic substances, while section 24 provides those punishment for external dealings in narcotic drugs and psychotropic substances in contravention of the provisions of section 12, and which restrict over external dealings in narcotic drugs and psychotropic substances. And section 25 of the Act provides the punishment for allowing premises to be used for commission of an offense relating to narcotic drugs and psychotropic substances. And while section 25A provides punishment for contravention of orders made under section 9A, and that particular section 9A provides that power to control and regulate controlled substances, as while section 26 provides punishment for certain acts by licenses or by the licensee or his servants, while section 27 provides punishment for illegal possession in small quantity for personal consumption of any narcotic drug or psychotropic substance or consumption of such drug or substances, while section 27A provides punishment for financing illicit traffic and harboring offenders. Section 28 of the Act provides punishment for attempts to commit offences under the Act, while Section 29 provides punishment for abetment and criminal conspiracy relating to narcotic drugs and psychotropic substances. Section 30 prohibits and punishes regarding preparation of any kind of coca derivatives, cannabis derivatives, or opium derivatives under the Act, and Section 31 of the Act provides enhanced punishment for certain offences after previous conviction, while Section 31A provides death penalty for certain offences after previous conviction. And finally, Section 32 provides punishment for offense for which no punishment is provided as per under the Act. And now we'll discuss about those punishments and the penalties imposed. So, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 1 year, or with a fine which may extend to rupees 10,000 or both, or when the contravention involves a quantity lesser than commercial quantity but greater than a small quantity, but greater than a small quantity with rigorous imprisonment for a term which may extend to 10 years, and with fine which may extend to Rs 1 lakh. And in case where the contravention involves a commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and also a fine which shall not be less than 1 lakh, but which may extend to Rs 2 lakh. So, these are the punishment and penalties as provided under Section 15 to Section 32. So now we will discuss regarding the very provisions relating to forfeiture of properties as it is provided under Section 68A to 68I. So, in particularly relating to such offences, for the provisions relating to forfeiture of property, as we found exactly under Section 68A, the provisions of the Narcotic Drugs and Psychotropic Substances Acts provisions will be applicable regarding forfeiture of property as provided under Section 68A, and Section 68B defines what exactly forfeiture of property means and how it would be forfeited. So, Section 68C provides prohibition of holding illegally acquired property as under the Narcotic Drugs and Psychotropic Substances Act, and Section 68D provides the very definition, meaning of competent authorities who would be engaged in forfeiture of property of such offences, while Section 68E provides identifying illegally acquired property through illicit traffic or sell, purchase illegally of any narcotic drugs or psychotropic substances, and Section 68F provides seizure or freezing of illegally acquired property, and Section 68G provides management of properties seized or forfeited under this chapter, and that is Chapter 5A as provided under the Narcotic Drugs, Psychotropic Substances Act 1985 and Section 68H provides the issue of notice or issuance of notice for forfeiture of property of such offenders or persons found guilty under the very provisions of Narcotic Drugs and Psychotropic Substances Act 1985. Finally, Section 68I provides forfeiture of property in certain cases where it is not found mentioned under the NDPS Act of 1985. And now we would like to discuss the very provisions relating to the pressure mounted on the Indian government and Indian Parliament to enact this piece of legislation in 1985. So the first one is the International Conventions under the Single Convention on Narcotic Drugs 1961 as it is provided under the very definitions of the Act under Section 2, subsection 9. So it provides that the Single Convention on Narcotic Drugs 1961 adopted by the United Nations Conference at New York in March 1961. And the second one is the very protocol amending the convention mentioned in the past, that is the Single Convention of Narcotic Drugs, which was adopted in New York in 1961. So the very protocol was adopted in March 1972 by the United Nations Conference at Geneva. Then finally, the Convention on Psychotropic Substances in 1971. This Convention on Psychotropic Substances Act, adopted in 1971 by the United Nations Conference at Vienna in the year 1971. So these conventions pressurized Indian government and the Parliament of India to enact this very piece of legislation. So, in particularly, we would like to discuss those amendments made into the Act. The first amendment that was made in 1988 as provided a new definition that was inserted under Section 2, subsection 8A, and that is relating to illicit traffic. And as regarding the second amendment in 2001 as NDPS Amendment Act 2001, which provided deterrent sentences and expansion of the very definition of addicts, and the Amendment Act of 2014, which provided wider connotation to what exactly essential drugs and what are for medical and scientific purposes are used, while the Amendment Act of 2021 provides the very rules on seizure, storage, sampling, and disposal of such drugs or psychotropic substances seized. And finally, in this year, in 2025, the amendment of the NDPS Act provides those regulatory frameworks for exports and imports of drugs or psychotropic substances. So now we would like to conclude the very lecture, and in regards to that we found that it is being criticized, and those critics of the NDPS Act say that the restriction that the Act is draconian and that it imposes on the grant of bail amount to virtual denial and ensure years of imprisonment. Critics say that the very conditions of bail under this Act are needlessly harsh and are similar to provisions of certain acts relating to India's national security and sovereignty and prevention of certain offences empowering to the national integrity. So, as per the periods of imprisonment and that of the NDPS Act places the burden of proof entirely on the accused to establish his innocence. Furthermore, some critics point out that under this Act there is a presumption of culpable mental state, that is, the court will presume that there was an intention to commit a crime. So they claim that this goes against the general principles of the law, where people accused of a crime are assumed to be innocent until proven, proven guilty. So we have completed our lecture on this very important piece of legislation enacted by the Indian Parliament after long pressure from the international community, in especially the American pressure after the international convention, that is the single convention on narcotic drugs, which was adopted by the United Nations Conference in 1961 at New York, and also the Protocol of Geneva of 1972 and the next convention, that on psychotropic substances, which was adopted at Vienna in 1971. So all these international conventions and the very pressure by the international community, especially the American pressure, which led to the Indian government, led by the then late Prime Minister Rajiv Gandhi in 1985, and the very Parliament of India, to enact this piece of legislation as Narcotic Drugs and Psychotropic Substances Act of 1985, further to insert what exactly illicit traffic means, as the amendment was brought in 1988, and besides that, another amendment was made in 2001 to the original act in defining and providing deterrent sentences and to expand the very definition and scope of addicts. And the amendment of 2014 to the act expanded and include what are the essential drugs for medical and scientific use, and the amendment of 2021, which provided stricter rules on seizure, storage, sampling, and disposal of such drugs and psychotropic substances seized under the very provisions of Narcotic Drugs Psychotropic Substances Act 1985. And finally, the Act was amended in this year in 2025, providing regulatory frameworks relating to very exports and import of drugs and psychotropic substances into India and from India. So we have completed this piece of legislation enacted by the Parliament of India in 1985 known as Narcotic Drugs Psychotropic Substances Act.